Good morning, everyone. Welcome to our Grandparents as Parents group meeting here in Cumberland County. And we're happy to have everyone here. We have with us today attorney Nathan Klaus. Nathan has kindly agreed to come and join us to talk about the challenges of dealing with custody matters in the legal system as it relates to our relative children and grandchildren and foster children and all of the above. So please help me welcome Nathan Klaus.
Thank you. So I said she asked me to come and speak today over probably one of the hardest topics in law that we do. This is one of the most challenging areas. It's one of the most highly contested areas. It's the most emotional area we deal with over anything else, and that's with kids in custody battles. One thing I want to start off by saying is there's often a misconception that if you get custody, especially as a grandparent, the parents have lost their parental rights. That's not the same thing. So I have often people come in and they'll say, oh, I need to adopt my grandkids. Well, we need to terminate parental rights. Well, I did that years ago. No, you had custody. That's not the same thing. So one of the things to understand is that in a custody area, the parents still have parental rights. They haven't lost those. Now, they might not be able to do the day-to-day operations, but those rights are intact until a court removes them completely, and they can still at some point try to regain custody. So that's a very important thing to understand, is just because you have custody doesn't mean those parents have lost their rights to those children forever. We'll kind of start out, there's many different ways, especially that grandparents today get custody of children. We'll do the most common, in my opinion right now, is through the Department of Children's Services, through an active DCS case. Those are done in the juvenile court here in Cumberland County. What normally happens is you have someone calls in a report, referral to the Department of Children's Services, whether it's an abuse or even truancy. It could be, when I say abuse, that doesn't mean physical. It could be they're home alone often. There's someone in the home doing drugs. There's like 13 or 14 grounds for dependency neglect the department goes through. You may have a child that's unsupervised for a period of time, and those sorts of situations. If the case is bad enough that the department needs to remove the child, because now they do sometimes leave the children with the parents and work a plan to correct whatever issue. But if it's an issue where the department removes the child from the parents and goes into the state's custody, initially what they should do is look for a relative to place the children with. They're usually children more comfortable with relatives. There's not the stigma of what they call foster care. So they look for that relative to place the children with. And most of the time it is a grandparent. They end up, DCS will do a background check on the grandparent. They'll go visit the home. Make sure that it's a good home, it's safe, make sure there's no history with the grandparent either. And if there's no even prior criminal or maybe a prior DCS case from 30 years ago, no matter what it was, they'll check all that out. If the grandparents or other relative are good and they pass the backgrounds, they will normally place the child or children with the grandparents. And this is where I want to say the fun really begins, because the world today is completely different than a lot of people who raise their children. And so when DCS says, hey, we want you to get custody, we're going to bring the children to you, and there's two types of custody. I'll kind of go over those in a second. When they bring the children to you and they say, do you want it? You're like, yeah, they don't really tell you what all you're going to have to do. They don't tell you all the appointments you're going to have to make and all these things, but I'll get to that too. But there are basically two types of custody for relatives in a DCS case. You either do it as a foster parent, which means you can actually take what they call path classes, which is parents as tender healers, and become a foster home. So you actually will get the monthly stipend and to help pay for expenses and childcare and clothes and food and those sort of things if you do as a foster parent. The other option is become a relative placement, a kinship placement. That you don't get the monthly stipend for that one. You're just kind of there on your own. and you're going to take care of everything yourself. The state's not going to help you other than tell you what you can and can't do. Okay, they're not going to give you
What's that called?
kinship placement. Now, as a placement with the Department of Children's Services, you're responsible for making all the medical appointments, make sure the children get there, make sure they get to school. If there's visits with mom and dad, you may have to take the children to those visits. You may have to actually supervise those visits, sit there with them, make sure they follow all the rules. If it's supervised, that means eyes on, ears on. That means you can't, if they come and say, hey, little Johnny needs to go to the bathroom. Well, we all have to go. You can't take little Johnny by yourself. I have to be there to see and hear. You can't even let them sit in a car and you stand beside the car if the windows are up, because you might not hear what they're saying. It is eyes on, ears on, which puts extra strain on the grandparents, because here's your child. They're going to guilt you like crazy. Mom, you know all this is not good. Dad, come on. I'm not going to do anything. And they're going to pressure you to give in to their whimsical ways.
Okay, I have a question.
Sure. No, you're fine.
As far as you said 2 types of custody. If it is a kinship placement, does this automatically mean that that everything has to be supervised? Is that part of this placement process that the parents have already been deemed unacceptable to be alone with the child?
There's 2 phases to it, but initially, yes. Almost every case, I've never had one in which visitation is not initially supervised, because if the parents have done something bad enough for the child to be removed, they're not going to leave them alone with that parent. They're going to want someone there to supervise it. So in both types, they'll start off supervised visitation. Minimum is 4 hours a month. That can be divided up. However, a lot of times it's 1 hour a week. Public places, even at the DCS office or something of that nature. But yes, they will all be supervised initially, just to kind of see the interactions. But when the kids are removed, the court, there's basically 2 sets of hearings, which I'm trying to dig too deep in the weeds here. It can get very convoluted. But there's basically 2 types of hearings that happen. The first one, the initial hearing, is basically, was there enough there for the state to get involved? It's probable cause. It's a coin flip. Doesn't take a whole lot. If the parent failed a drug screen, that alone can be enough at certain instances for the state to be involved. If there was, for instance, I'm going to say little Johnny came to school with a black eye, and he said, "Mom hit me," or "Dad hit me," and they investigate, and they say, "Yeah, this occurred." Just the fact that the child has a bruise and the child said Mom did this is enough to probably get past the first hearing. It doesn't take a whole lot. I had that happen to a lady whose daughter was back talking her, and she smacked her on the face. It didn't bruise or anything, just had a little mark, and she was kicked out of her home. The mother was made to leave the home. Dad was allowed to stay. There was other children, but she was out of the home for about 6 months, trying to fight to get back in because of back talking. And her, I think the little child called her a word that wasn't real nice, and she smacked her across the face. Won't be the first time my mom smacked me when I was a kid too, but can't do that. But yeah, alone that enough can get you to pass the initial hearing.
So a person can't even spank their kid?
They can spank them. You can spank them on the bottom. You can't leave marks or anything like that. But yeah, you can spank their butt. I mean, you can bend them over and spank them, but otherwise you're not going to smack them in the face. You're not going to smack them across the back. They want it on the bottom, and you're not going to leave marks. If you hit them hard enough to leave marks, then they're going to label that as abuse. Now, if they're red when you get done, that temporary thing, that's not gonna be a big deal. If they have a handprint the next morning, that's gonna get you in trouble. If there's a belt print or something like that, that's gonna get you in trouble.
So Nathan, just a quick question on that. So I know that's the case with the parent. When they're placed in foster care, though, even any form of corporal punishment, we were advised
None.
is out.
None.
So if it's a kinship placement, then you
you're limited. You can do timeout, you can do, but you're not, as the placement, what I was talking about was the removal part. But as a placement, you cannot do physical punishment. Nothing that's corporal, like I said. You can do timeout, you can make them write sentences, you can do that kind of stuff, but you're not allowed to physically punish them, even with a spanking as a placement. They will not let you. That does cause issues sometimes, especially in foster placements that are not parent related or grandparent,
In
but
the kinship placement, you have all the responsibility. You have no government, I would think, oversight if you're the grandparent and you're not getting any kind of help from the government. But still, you're treated as if you have all
the
you
this
have to jump through all the bells and whistles and can't treat them like your own children.
the state's still going to be involved. They're still going to come to your home. They're going to check on the children. The caseworkers are usually required to come once a month to the home to check on everything. They're still going to be watching over it. If something goes wrong, they'll take the children from you.
What would be the benefit of even having a kinship placement?
It's comfortable. It's more comfortable for the children usually. If I place with a grandparent, the child is usually more comfortable.
But if the grandparent went through this training program and became a foster family, the child would know the difference. Because it's still gonna be
Well,
grandparent. Okay.
the biggest difference, there's a big difference in that if in a foster placement, it's kind of, having been a foster parent, you understand children have a stigma of I'm in foster care. Whether or not it's with grandparent or anybody else, if they're in foster placement, there is a whole different stigma that associates to the child. The kinship also, it does have a little more advantages. I don't want to go into all the different weeds, but there are some advantages to kinships, especially parent-wise. Kinships are usually a little easier to work for the parents. They usually more flexible on visitations. You're usually more flexible on phone calls. Whereas if I'm in a foster situation, I got a foster parent, we're not doing, I've got 4 other kids, we're not going to do this. One of the biggest issues with kinship, and this is my personal opinion, is it also makes the parents real comfortable, which can be a problem. If I'm a drug user and I'm like, my kids are with grandma, they're safe, they're secure, I don't have to worry about them, then where's my incentive to work my plan? Because they're with my mom. She's not going to hurt them, and if they close my case, mom will still let me see them. They get a lot more comfortable. Whereas if it's a foster placement, they don't terminate parental rights out of kinship usually either. But out of foster situation, if the parent doesn't work their plan, they'll terminate parental rights. That right there alone sometimes is you can lose your children forever, even to grandma and granddad, if you don't work this plan. So foster care sometimes has a little more push behind the parents than anything else.
Our situation was such that we had to become foster parents to get Lily out of foster care in Alabama when the adoption that was supposed to take place fell through. It's a job becoming a foster parent, and it is a job being a foster parent. I mean, the paperwork, the amount of effort. Yes, you do get paid. We didn't, because Alabama didn't pay us, as it turns out, but because in Tennessee we're not a licensed foster parent. But there's pros and cons to both sides of it, and so it's challenging to make that decision as to whether or not you want it to be a kinship. When we then tried to get parental rights terminated, we had to pay for it. Whereas if you're a foster parent and it's gone through the state, everything we did on our own, and we paid a ton of legal fees.
Mhm.
But if you're working through DC then they're gonna pay for it, and if you ultimately adopt the children, they're going to pay
For that.
the attorney's fees for that. We had to pay the attorney's fees, for
Yeah.
that. So there are definite pros and cons to both directions, but
Yeah.
you're right. We had to initiate the TPR process, the termination of parental rights process, and pay thousands of dollars in order to make that happen.
And understand too, foster parents, when you become a foster parent, the state, they get to know you pretty well. I mean, the questionnaire, the stuff they go through, because not only do you do the classes, and those classes take a while. I mean, they're pretty extensive, and they're like usually it was once a week, and they go for like 6 to 8 weeks. There's several hours. You got continuing ed if you're a foster parent every year. You got to go to seminars. But just because you do the classes don't make you a foster parent. Then you got to go through your home study. And they're going to teach you medical to see what kind of shape you're in. They're going to come into your home. They're asking questions. How did your parents talk to you about sex? How were you raised? What did you do? They're going to separate you and your husband where your husband don't get to hear what you say and you don't get to hear what he says. And they're going to compile all this data. And then if everything else goes good, you get approved of foster placement. So they're a lot more intrusive when you are fostering than when you're kinship. Kinship will come in as long as you pass their background check and your home is acceptable, they'll place. You don't go through all the other rigmarole of having to do these extensive classes and all that kind of stuff.
Will DCS place somebody temporarily in a kinship home while they work through the foster, if they decide they want to work through the foster parent? Or do they place them somewhere else and then wait until you have been approved as foster parent?
They will sometimes place with the kinship while they do the path classes. They have an expedited path program sometimes for kinships to try to speed it along so that you can get licensed quicker. But they still go through all that just rigmarole. And the other things that, and I'm kind of getting off on left field here, but not only do they help with fees, but if you have a child that is severe abuse child, and that's severe abuse is kind of a broad term, there's a lot of stuff in there. If you do a termination and an adoption to Department of Children's Services in a severe abuse situation, that child can also get college when they go to college and get that paid for. You also continue to get that monthly stipend even after the adoption's over with, if it's a severe abuse situation. So there's a lot of different pros and cons to both, but yeah, there's a whole lot to that. A lot of times they do kinship placements because they can close them faster. If the parent's not working their program in about 5-6 months, they'll just close the case. Giving the grandparent permanent guardianship, or it could be an aunt and uncle, but sister, but they'll close the case, giving them permanent guardianship and just close it. And that's just it. Whereas the foster situation, some of those can go for a couple of years while you're going through. I had one that I was in, it was 4 years before they finally terminated rights. They lost the first termination hearing, had to start all over again and go through that. So it was quite challenging. But going back to initially, there's the first hearing that you go to. The parents can waive that hearing. They can say, look, just keep me on down the road. I'm going to waive this first one. The next hearing is what they call adjudicatory, which requires more proof. And everybody knows criminal law has beyond a reasonable doubt. Well, there's actually multiple levels of proof. In adjudication, it's not beyond a reasonable doubt. It's what they call clear and convincing, which means it's clear to the court and it's convincing enough from them. It doesn't have to be that this is exactly what happened or it's exactly dangerous, but it's clear enough to them the DCS should be involved. Then they will leave the children in their placement, whether it's foster care or kinship. And the parent will work their plan to get the child back. If the court dismisses it, the child goes back home. But that's kind of the last chance to really fight until you complete your plan. But both those work in kinship and foster placement, they have those same two hearings that the parents can participate in and try to get their kid back quicker. But once you get past the initial hearings, which is usually done within 60 days, they technically should have those done pretty quick. Then it goes through the process of the parents working their plan to try to get the children back. That can be take drug screens, go to A&D assessments, psychological exams, got to have a job, car, place to live. They'll give them this list of things they're supposed to do based on what has happened. If it's a physical abuse, they'll have to go through a domestic violence assessment and classes and parenting classes and all that. If they complete all those programs, then they will, and through that process, they'll start gradually getting more visitation. They'll gradually become unsupervised, start doing overnights, and then eventually do a trial home visit with the parent given the opportunity to be good for about 90 days. At the end of that 90 days, they return to parent. But that is the most common way that grandparents live with kids today, is through a Department of Children's Services case. There's a lot of them. And it's become more popular in the last few years, especially with grandparents now starting to take care of their grandchildren. But it's very taxing, and I don't have to tell anybody that if you've done it, it's very taxing. Like I said, but DCS are going to require them to make all their medical appointments. If a child has any kind of services, they're going to have to get the children to those services. They'll ask them to take them to visits. Technically, DCS is supposed to help you with that, but the caseworkers are really overloaded, and a lot of times they can't fit it in to get those children to places. And your visitation may be Coville, it could be Knoxville, it could be, depending where the parent lives and where you're at, the visitation could be an hour away. So an hour visit may be a 3-hour ordeal. So it's when you take on those roles, you have to understand it's going to be a lot of your time, but you're going to love the child anyway, whether it's the matter situation. But you're going to have to deal with a lot of the parents trying to push their parents to do more, because DCS will never know. But if DCS finds out, they'll take the kids from you too. So that just makes it a whole lot worse. Yes.
So I see a lot of, and this is addressing what Renee was saying earlier about the fact that a lot of family members just step in and take where there's a need, take the children. And I've talked to grandparents or relatives out there who say, okay, I could spend, it doesn't necessarily get to the point where DCS steps in. Okay. They see mom, dad, using drugs. That's not a safe environment. We're going to take the kids out because they can't take care of them. And they don't want to spend a couple $1,000s in order to get custody of the child. So what are the benefits of spending that money? Because I mean, that $2,000 can be used for clothing and food and, things like that. And what are the risks related to not getting legal custody?
So here, I was going to go down the pathway of what they call emergency custody here in just a second. No, you're fine.
Is that what you described?
Basically, that's where you actually step in and get a court to get involved yourself, where you basically act as if you're the department and you file your own court documents to get custody. Now, having the benefit of using the department, and I've actually recommended this to people, because a lot of people are on limited means. So if you have, I had a lady come to me about 6 years ago. Her daughter was doing drugs. She knew it. Her only income at that time, she made $860 a month Social Security. That was all the income she had. And she said, how can I get custody? And I said, well, don't hire somebody. It's going to cost you too much. I told her to do a referral. Go ahead and call the Department of Children's Services and let them get involved and let them do it for you. Let them investigate and save your money. And it worked out for her. She ended up, her daughter went to rehab. I followed up with her about a year later. She was actually still in court and talked to me. But going back to what if DCS doesn't know? Do I call a referral or not? What do I do? If you're a grandparent or any relative, You don't have to be a relative. If you're a next door neighbor and you see that a parent is abusing, and again, abuse is a broad term, doesn't have to be physical or anything like that. There's, like I said, there's 13 grounds for dependency neglect, 13, 14. If you think a child is being neglected or in danger, immediate threat of harm, then you need to hire somebody. I wouldn't try to do it on your own unless you get the department. But if you know that there is something happening in the home, if you know that your daughter's doing drugs, let's say they're living with you and you know they're doing drugs and you do nothing. When the department comes in, they now find out something at school happens, that school's called, or maybe a counselor's called that they're seeing, and they say mom and dad's doing drugs. They come in your home, they may not place with you because you allowed it to happen and you knew it was taking place. So they may say, we don't trust you. We're not letting you have the children. So to do nothing is actually not a good thing. But you can either, like I said, you can call the department, or you can do what they call an emergency custody. And that's if there's an immediate threat of harm. And what that basically entails is that an attorney will draft the paperwork and go before the judge and ask for what they call an ex parte order. That means there's no other side present. Nobody else has heard the side of the story yet. The judge only hears what that attorney is telling them. And the judge, 99% of the time, out of precautionary, will sign that ex parte and saying you now have temporary custody pending a hearing. But the attorney has to have the groundwork. Goes to the judge. Judge, here's the facts as we know them. This is happening. I feel the child's dependent, neglected because of X, Y, Z. And the judge will look at it. If it says, well, the kid didn't get Christmas presents. No, that's not going to work. But if you're like, look, I saw mom, when they opened the door, there was a needle laying on the table, or I saw the child running around, feces on the floor, something of that nature, a health issue, or the judge will, a lot of times out of a bunch of caution, will say, I'm going to give you, whoever you may be, a temporary custody while we figure out what's going on. And they have to have that initial hearing within 72 hours. And so the parent will come in, they can get an attorney if they can get appointed counsel. They don't have to hire one unless they make too much money. The court will appoint them. Yes, ma'am.
Does the state not get involved at that point?
No.
Really?
No, you don't have to notify the state.
I would think the courts would, where I come from, the state's always involved.
No, the state does not get involved. Now, there can be issues where the judge may say, look, I want the state to investigate this.
Yeah.
I've had that happen, but they don't do that in every case. No. Out of all the mercy custodies, I've done several. I have never had DCS involved after I've done it. Now, I've gotten calls. So I've had a couple where DCS was investigating, and they've told grandma or granddad, look, we're going to take the kids unless you get something done. And they'll come hire someone like me to go ahead and get emergency custody, and the state will back out. We're not going to be involved.
They prefer to because they don't have to take the risk. And they don't have the time to do it.
Yeah. And then it's in the hands of the judge to.
That's my case, but it's not in Tennessee. My case is in Wisconsin. And it's the neighbor reported neglect of the kids. And DCS stepped right in immediately. No one else even had a choice. They stepped in, they did the surprise visits and things like that, and they took the child away.
Well, that is, if I'm a neighbor and I report it on their hotline, DCS gets involved.
Okay.
But if I'm a babysitter, and you bring me your child and the child's got bruises on it, and the child says, this is what happened to me. Even as a babysitter, I can go to an attorney that day and say, this is what has been disclosed to me. And that babysitter can get custody through a court order right then. And then it's.
I've been in custody now for 16 years.
Oh, I wouldn't say it's often a babysitter. I've only had one case which a babysitter did it. But yeah, we do. There's emergency custodies. I wouldn't say quite often, but there's several. Um, but you have to have emergency requires there is an immediate threat of harm. And it's for the best interest of the child. But yeah, there's emergency custodies. I probably have done maybe 3 or 4 a year. But there's some attorneys in town that have done, they may do 2 a month, 3 a month. And sometimes those aren't the best ones. A lot of times, the problem with that is you have someone who comes and they tell you, here's the facts. You file your paperwork, you come to court and you find out that that's not really happened, but you just removed the child for 3 days. And that may not be the case. I have had where actually it was a 16-year-old came with a friend and their parents, and they were talking about dad has done XYZ, and they told me all the stuff dad had done. There's a dad and stepmom. Dad had hit him. And he was sitting there verifying. I was the juvenile was in there with me, verifying all this, and he was scared to go home. He was afraid of what was going to happen. We got emergency custody. We get to court. Turns out the night before the kid had driven down to dad's work. They went out to eat. They had done the day before I took it out. So he wasn't afraid. None of that stuff was actually truly what happened. And so I just took this child from this home for 3 days because the juvenile's telling me, but wasn't truly legit. Now, I did what I thought was necessary based on that juvenile talking to me. So did I feel bad? Yeah, but it was at the time it was what needed to be done.
So the juvenile just lied to get back at the parents.
Basically.
Way, shape, or form. And
Well, there was something the juvenile wanted to do and dad wouldn't let him. But it's harder when but that's why those hearings have to be had within 3 days. That 72-hour window tries to ensure that kind of stuff doesn't just happen. That it's not a regular occurrence that there's false allegations made.
It's nice, it's only 3 days. Where I was, they were taken away for 2 weeks. And it was found totally unfounded that kids have been out of the home for over 2 weeks.
What can happen? So let's say I file an emergency custody, and it just says within 3 days. So I file, the only time the court has an opening is tomorrow morning at 10 o'clock. But when I file that, I still have to get the parents served. So let's say they don't get served until the next day at noon. Well, they missed that hearing. So now I've got to reset it, and it may be 2 more weeks afterwards. So, and sometimes it's hard to get parents served. It may be that you would think, well, why wouldn't the parent worry why they get their kid back that night? It could be a number of things. Maybe they're like, the parent is on drugs and they dropped the kid off and they're gone for 2 or 3 days. Or perhaps I've had situations where parents have dropped off and just left town and left someone with no way to care for a child. You do emergency custody. It's not just if you witness something, but if I'm here in town and all of a sudden my neighbor says, look, I've got to leave town and can you take care of little Johnny? Yeah, I'll watch him for a couple days. That's fine. All of a sudden it's 2 weeks. You haven't heard from mom. School's starting in 2 days. You might want to go get emergency custody so you can get that kid in school. It may be only because you need to do something like that. The parent maybe, you don't know what happened. Could be something wild, but I have had situations where we got to do something. The child's got to get in school. I don't have custody. I don't have power of attorney. I can't enroll them. And the only reason we did it was so we could get the child in school. There's been weird situations like that. And it's really not something the parents were truly neglecting the child. The child's being taken care of, but there was another issue that they didn't see when they took off for whatever reason. Yeah. Yeah.
We actually represented ourselves and we achieved our goal. But the most frustrating part of it was probably service and process.
Mhm.
We were told to place the pleadings with the sheriff's office. And they never went out and aggressively sought out service. Now, was that because we weren't pulling the right strings, because we weren't attorneys, or is this a common problem?
The sheriff's department here usually does really good work. What you run into is, they're serving warrants all over the place. And it may be 3 weeks before they get it to serve it. But then they're going and they don't have time to go back 2-3 days in a row. So they'll go, okay, I'm going to go, nobody's home. They might not get a chance to go back for a couple of days. They may come back and say, I couldn't find them. Because, they've got to watch out for everything else going on while they're trying to serve this process on somebody. And in the meantime, maybe all of a sudden they get a call, there's a robbery or something like that, and they're set it down, they'll get to it for 2 more days. So the problem there a lot of times runs around the timing with the sheriff's department and their ability to fit it in among everything else.
So they don't necessarily have a dedicated civil service process officer or department?
They'll give it to a deputy going out.
All right, one other thing then.
Mhm.
I got frustrated enough that I went down there one day and I said, I know you haven't gotten service on this, but could I see your log of the efforts that you have made? Because I figured at some point I might have to demonstrate reasonable efforts to get service. And they looked at me like I was from some other state
Yeah.
or planet.
They don't log it.
Thank you.
No.
Just want to make sure
The-
they weren't jerking
no.
my grades.
There is a warrants officer who initiates them, who gives them out to be served. She does a fantastic job, but not all officers work all the time. They have so much time on, so much time off, and trying to make sure and try to keep up with who does that headache. I normally do a private process server, is what I use. I have a couple that I use. They're usually served within a couple of days. They'll usually do 3 attempts. Now, a lot of times one of my use, especially a phone number, they'll call them. Hey, I'm looking for you. Where you at? I've got this for you. And they'll go meet them a lot of times, or they'll say, do you know where they work? And they'll go to their work if they've been able to see them at home. So a private process server is used quite frequently. I'll give you an example of the sheriff's department. So if I file, and this is not against them, but this is what happened. I had a case. It was actually, I think it was actually Mercy Custody, if I remember correctly. Mom was in jail, and no, it was a termination of parental rights. Excuse me. Mom was in jail. I filed it. I said, I'll let them serve it. Mom's in jail. I mean, the clerk's office is on this end of the building. The jail is on this end of the building. We go from here to here. But because of the filing and then everybody getting them and taking them around, it was 3 weeks.
What? Oh my gosh.
The mom had gotten out of jail, so we couldn't serve her. She was out by the time we got it over there. But it was just because of the way the filings and, somebody's on vacation here or whatever, and trying to get all the paperwork shifted. It took quite a big time. Occasionally stuff like that happens. But now I've actually served them with a private process server in the jail. I actually will have them bring them up and have my process server serve them in the jail.
But the temporary custody continues in place until such time as they are served in the hearing itself. Correct?
Yeah,
Or do you
so-
have to go back every 3 days and get another
No.
emergency.
No, it stays in place. So what the court will do is give you the temporary custody. You go to that initial hearing. If the parents show up and say, look, we want an attorney, they'll leave the child with you and they'll reset that hearing. If you have alleged that the child is dependent neglected, you have to have the 2 hearings like you did before. And so if you win the first one, the temporary custody will still stay with you until the final hearing, whatever that final hearing is. And at that point, if the judge leaves custody with you, it's no longer called temporary. Like, people call it permanent, but you got custody, but it's really not permanent. The parent can still come back at some point in time in the future. But they will leave custody with you in a final order pending any further litigation. But if it's not dependent neglected, it may just be one hearing. You can do emergency custody. If the attorney doesn't allege dependent neglection, that has other things that can hurt that case too. But if it's, I had one that really went dependent neglected. I had a mom who had dropped the child off, went back, the landlord was evicting them. And so they had no home. And so they said, we're going to leave the child with you, but they didn't give a power of attorney. And all of a sudden their phones were disconnected. And so I had to do emergency, just like I said, for school and those sort of things. We were able to find, mom actually was able to call sometime and find out what we did. And we didn't do dependent neglected. It wasn't like they left the child wanting disregard or anything. But mom, when she got housing, we agreed we'll do this right here until mom gets housing back. As soon as she got housing, we went in and gave the child right back. So it can be truly temporary. It can be until they complete a laundry list of items. Yes, ma'am.
I'm sorry, I missed the first half hour.
Oh, fine.
To get here, and I couldn't find it. I assume, I suppose you probably already covered the difference between guardianship and custody?
Not yet.
Oh, okay.
I'll get to there. In just a minute, I'm going to go a little more about what guardianship is.
I have you had asked something about the advantages versus the disadvantages of getting custody. After 16 years, I have a list of horror stories that long from people that never got custody. It doesn't work. It never works. And everything on my sites and everything, you go in there and they say, well, I'm just watching the kids, I take care of them during the day and they live with me, but the parents are still involved in their life and stuff. And I'm like, everyone says, get custody. You have to have custody because at some point in time, there's going to be a clash and someone has to be able to make that decision.
Right. If you don't do a custody or have a custody order, give me the right to do physical, psychological, medical, and all that. If you're just like, I'll keep him. If the parent shows back up,
Yeah.
give my child. Without that court order,
You can't take them to the doctor.
yeah, not without at least a power of attorney in hand. You can't get a power of attorney. So I do that. If I'm going out of town, I'm leaving. Right.
Yeah.
They're going to need something. Now, there are doctors around here that know the family's well enough. They'll do it without the power of attorney. But going back, so you do the emergency custody. If you get permanent custody, you'll get to keep the child until such time as the parent repetitions the court to get the custody back. And they'll have to go in and show that whatever the issue was is resolved, and they can get custody back. Now, it could be 7 years down the road. I mean, it doesn't. There's no time frame that says you've only got X, Y, Z to do this. It can be several years down the road, and parents all of a sudden come back and go, my children back. I'm filing with the court to get my kids back. Because you didn't really terminate their rights. You just got custody, and they can do that. So, yes, Tom.
I just had a question. So when you were talking about emergency custody, you said some of what prompted that was maybe it came to your office. In the state of Tennessee, anybody who suspects abuse or neglect is a mandated report to DCS, correct? Or are there other channels? I mean, as a school, I think that's always going to be.
You're going to have to.
Okay.
So where that plays in with me is if you come to me and you're doing this to stop it, I'm not going to call DCS. We've taken the child out of the, but if I hear about it, I had someone call me who I knew, said, hey, this is happening. What do I do? And I said, you need to do something. If you don't, I've got to report this because you have disclosed to me that this child's in harm. I have got to report this.
Is it true that everyone is mandatory?
No, not everyone's mandatory, but it's, of course, it's all anonymous anyway. So if you feel something's going on, call it in. I'm not going to say,
Right.
yeah. But I am obligated if there's a situation in which I had one that was actually an elder abuse situation that got brought to me. I had to call Adult Protective Services. I had to let them know something was happening. I had to report it. Different professions have different things. If you come to me and you're going to sue self-harm, I have to immediately call and have them come if I think you're going to hurt yourself or someone else. I mean, there's certain things, but yeah, I won't report it if it's something I'm taking custody and I'm protecting that child. I will not call DCS. I'll let them kind of work it out. Because in a custody case, emergency custody or otherwise, the child will normally get a guardian ad litem if the case goes past that initial time. And the guardian represents the best interest. They're going to be investigating as well. They're kind of the eyes and ears for the court. And they're going to come in and kind of tell you what I think is going to happen. And they'll talk about it. Guardianship is basically if there is no parent available, the parent's deceased, or you've had a case such as DCS where you've gotten custody through them and they'll close their case and give you a guardianship over the child. And it's basically custody on steroids. Whereas a custody order you have the psychological, emotional, medical, school authority. The statute for guardianships will give you, contract negotiations, bank accounts, and it'll list all these powers enumerated in the statute. So it's kind of a custody on steroids, I would say. You have a little more authority, a little harder to break a guardianship than just custody. They've had another level technically that for you to get guardianship over them, because basically then you've completely taken place. Yes.
With guardianship, is that after, or can the parents still have parental rights at that time?
They still have parental rights. They still have, yeah,
Work in conjunction.
it can. But most time you get guardianship. Now DCS, they call theirs a permanent guardianship when they close their case. The guardianships that I do is parents deceased. There's no one for the child to go to. I will do a guardianship for someone to take the parent role, not necessarily emergency custody. There's no parent to serve, so you ask for a guardianship. I actually had a young man. He was living with his aunt and uncle. His mom was sick. His mom died. Well, in order to keep, because at that point, there's got to be a parental role. So we did a guardianship over him because we were next of kin. We were able to come in and say, hey, we're next of kin. Here's mom and dad have died. Child's familiar with. So the court gave guardianship, kept DCS out of it. If I'm underage and my parents pass away, unless I do something pretty quick, state's going to take the child. Okay. So guardianship it's just a little different animal, but only do it when there's not a parent to even consider. That's when I don't, or otherwise I do custody orders. But if there's not a parent at all, I'll do a guardianship. Once they're 18, you convert it to conservatorships if needed. But yes, ma'am.
Well, since mine is from a different state, it would be a lot different, but I'm curious, in Tennessee, one of the parents are incapacitated in jail for 20 years, or
You can,
disabled, or and can't afford the child, or just are on drugs and alcohol for years. Will they then grant guardianship?
they can, you can use that. A custody order will get you the same area, the same way. And a lot of times everybody treats them kind of identical, but we do guardianships. You can do a guardianship if a parent's gone. There's no parent to be had. It could be there sitting in the state or wherever for the next 30 years. I just did one where there's two guardians. This was actually granted in California, where mom, the lady I represented, got guardianship in California. She's here. Mom hasn't seen the child in like 6 years. She's now got medical problems. So we put another guardian in place, co-guardian. So when something happens to her, the child has someone to go to. Whereas if she just had custody, if she buys, nobody has custody. Custody kind of goes and disappears. Whereas guardianship, you can kind of carry on to. You can go ahead and ask for a co-guardian and do a co-guardianship over the child. So you may have two people that can do everything else. Now, if you have grandparents, will have joint custody. But let's say if I'm grandma and I'm not married, but I've got my grandchild, if something happens to me in a custody order, that custody order is gone. I'm the only one that had it. Whereas a guardianship, I can go ahead and add up my other daughter, or so there's no lapse in time. They don't have to go out and try to find them. Yeah, every state does stuff a little different.
They have a stroke or something, you know, but I have permanent guardianship.
Then,
So I've
yeah,
been told he just goes back to the state.
he would if there's nobody else that you put a co-guardian. See, the statutes,
He won't let me.
you're here now.
I don't have guardianship in Tennessee. It's still through. He's 16 and a half now. We only have a year and a half left, and it would have cost me over $10,000 because the parents in Wisconsin retain parental rights. I
How
have one that will not give them up.
how long have you lived here?
10 years.
Probably should transfer the case here.
It will cost me $10,000 because we can't terminate the parental rights.
You don't have parental rights to transfer the case. I transfer the case from California to here. I just did the guardianship here. It wasn't nowhere close to what you're saying.
Even if it's contested?
If they-
Back a year ago and the courts refused them.
Well, what I did is open the case here. Tennessee now has jurisdiction. The child's lived here. I just basically reserved the parents and said, hey, we got another case here. Let's go. Nobody ever showed up. But Tennessee, the statute says guardian or guardians. So it can be plural. You can have more than one guardian. You can't have more than one conservator. For an adult, it's conservator. But the statute here says, huh?
We don't do that.
Yeah.
See if they-
But here it's guardian or guardians that actually has a pluralized in the statute. So you can have more than one to do so.
If you have physical custody of the child, you've been appointed guardian.
Mhm.
Okay. You can get a co-guardian, and that doesn't mean that they have to have physical custody.
No, what I did, because the lady I have, her daughter lives in North Carolina. But the child's familiar with her. They're not really related, but he's familiar with her. She actually came to court. The young man came to court. He's autistic. He came to court and said, yeah, I want her to. But he had a relationship with her. And so we were able just to add her to go. So whenever something happens to this lady, she's just going to take the orders and go off back home with him. Mom never did anything. We sent her notice to California and worked it out that way.
Cases of grandparents who are losing, who are acting as parents, it would be important to have a guardianship and a co-guardian because of most of our ages.
Yeah.
it would be under that.
And I think guardianship, custody, you might be able to navigate some stuff in an estate issue also to appoint a guardian through an estate issue as well. Custody, not so easy, but a guardianship, you might be able to navigate and actually put kind of a guardian in an estate package as well. It's a little different. Like I said, there's a little more teeth there than just custody.
So if you start out with custody in the state of Tennessee, you can go through the legal process and change.
Make it a
that to
guardianship.
guardianship. It's sort of like two together.
Yeah, you actually go and petition for guardianship. I've had custody for whatever. I want to make this a permanent guardianship. Like I said, it's not a termination of parental rights. They're still intact. But it's got a little more. Yes.
This is more from the school counselor point of view. In Florida, our laws are different, obviously.
Mhm.
one thing that I always struggle with grandparents who are kind of parents in a way where, you know, they spend the day with you, go home at night because parents work, whatever, be it daycare, if you will. They call and they go, I need to see Johnny's record before we cancel.
Mhm.
Does Tennessee power of attorney is suffice in such situations?
You would probably need to spell it out. Power of attorney is usually
No, power of
just,
attorney for education.
yeah, if you had something spelled out, you had educational records access, yeah, you could
That's
get
kinda
it.
what I was
Yeah.
thinking when I was power of attorney. I
Yeah.
wasn't meaning broad stroke.
Yeah, you can specifically say they have access to records and those kind of
In
things.
Tennessee, what's the difference between power of attorney and custody? Where's the overlap? Where is it?
So a power of attorney can be revoked. So if I'm a parent and I give you power of attorney to do medical, all I got to do is say that's no longer good.
So it's granted by the-
It's granted by the parent. And they can just say this is no longer good. This person can't use this anymore and it's gone. Whereas custody orders gives you that until the court takes it away.
So in guardianship, you have both.
In guardianship, it's one, it's everything in one. You can, they have to go to court to take it away, and you have authority just for everything. I mean, you basically are a parent. And I know that sounds confusing, and I'm not trying to get too like this. There's a lot of interplay here, and I'm trying to broad stroke it and not get too. No. I love the questions, but when I'm talking, I'm trying to make it too complicated. Trying to keep it simple. I'll answer the question. I have no problem with that.
I guess I found through my years that, including myself and happened with, people make it too generalized, and it's not. You come across all kinds of pitfalls and holes and hoops you have to jump through and everything else, and you're not prepared for that when you sign up for it.
Right.
And I found that a lot. It's like, I have a lot of people that have, a lot of people that have abandoned personally know one that's abandoned their guardianship because they didn't know everything they'd have to do.
You got to do reports to the court. That's another thing. You may have to report their finances. So if they're getting some sort of disability check or income, you may have to do a yearly accounting of their monies. You're going to have to do different reports to the court as a guardian. There's a lot more requirements on you as well than just having custody. As a guardianship is going to have all these mandatory things you've got to report to the court every year unless it's waived. You may have to actually file a bond to cover assets of the child. There may be a need for a yearly accounting, and so I mean there's a lot more in the guardianship realm than just, like I said, it's kind of on steroids. There's a lot more to report, and the court kind of keeps a closer watch on if you're doing your fiduciary duties with the child's money, if you yourself are if you're not protecting it, there's a bond in place to protect that money. There's a lot more to it than just having a custody order. The court, once court gives you custody through a custody order, they're not going to follow up with it anymore until somebody repetitions. In a guardianship, there are requirements unless the court waives those requirements that you have to do every year. So it's an ongoing process unless that court waives those. And sometimes they do. Yes.
I apologize. I have to go to another meeting,
Sure.
but I have a question.
Yeah.
Again, as we went through this process, we seem to get confronted with two different standards for making decisions. One was reuniting the family. The other was the best interest of the child.
Yes.
And we sort of approached this that it ought to be the best interest of the child. DCS certainly doesn't take that approach, or didn't with us. What's your thought about why those two standards seem to conflict with each other? Should they, or is it statutory?
So every custody case is best interest, every one of them. The goal of a DCS case is return to custody if it's in the best interest of the child. That's kind of a caveat. So I'm not going to return to you if it's not in the best interest of the child. Shouldn't. Every custody case is best interest. Now, what is best interest? That kind of gets a little more, if it depends on what you think is best and what the court would deem is best, maybe two completely different things. But every case when we do custody, this is in the best interest of the child. If you don't have that in there, then it's not gonna hold water. So every finding has to be best interest.
We got frustrated first because it seemed like the judge was only interested in reuniting the family, notwithstanding that it may not be in the best interest of the child.
The guardian ad litem said it wasn't in the best interest of the child.
But the court's primary goal is reunification.
Okay.
So if it may not be best yet, they're still going to push for reunification. We got to get them there. We've got to keep trying to get them there. If they don't ever get there, then it's terminate. So that it's kind of up to when the Department of Children's Services says we've done all we can do. They're not completing their plan. They're not doing anything. Now we're going to convert this to a termination. But until that time, the court is going to say, what can we do to try to reunify? What services do we need? Do we need a different counselor? Do we need all this? Trying to get them to where then it becomes the best interest to reunify. But they're going to push for reunification and try to meet that plan. If it fails, it fails. But the ultimate goal is reunification by making it the best interest of the child to do so.
We would have been so much better served if you'd been on the bench and you'd have been explaining it to us the way you just did.
Well,
Because we didn't hear it that way.
yeah, that's the way it works.
Thank you so
Oh,
much.
you're welcome.
Thanks.
You're welcome.
Appreciate it.
No problem. All right.
So let's say we have gotten custody, not through DCS.
Mhm.
At what point, in your experience, would a grandparent feel, or why would a grandparent or a relative say, you know what, we don't want the custody thing anymore, we actually want to adopt, we want to terminate? Why would somebody move forward with that in your experience?
Well, there's a couple of reasons. Let's say for one, you're older and you're like, look, my time may be limited. If I just have custody and I haven't done it through DCS or anything like that, if something happens to me, the parent's the first option for that child to go back to. Okay. It may have been 8 years since they've seen them, 10 years since they've seen them, but they are the first option for the child to go back to. And you're like, I can't leave this up to chance. So I'm going to adopt them. That way, once I adopt them, I can say, here's who I want to have these children when something happens to me. You can put that guardianship provision in your will that says, I want XYZ to be the guardians of my child.
If I
Yeah.
put that in my will here in Tennessee, but the guardianship is in Wisconsin, what would happen?
That might get a little hairy with Wisconsin. Yeah, it
He
might.
can't go back to his dad, he won't.
He's 16 and a half.
He's 16 and a half, but
So-
Wisconsin is extremely a parent's right state.
Right. So here's,
It's right up there with Colorado and Wisconsin are about equal.
you could put in your will and see what happens. I'll be honest with you, because you're gonna have two states conflicting.
I don't want to leave it up to chance, but the
It's-
option is, I can't afford it.
So I would put it in my will that I want this person to be guardian. I would do my best to try to find a way to put a guardian in place court-wise. That's my opinion. I would try to find a way to put a guardian in place court-wise. The biggest issue you have is that the case is ongoing, but it's just because it's guardianship, just because there are reporting requirements. He can try to undo the guardianship, but right now, the only tie to, or what should be the only tie, is your annual reporting to Wisconsin. There shouldn't be regular hearings anymore.
I don't even do annual reporting.
So I would,
I'm under DCS down here.
the one I did, well, now yours is through a DC, that may throw another wrinkle. The one I did, I honestly, I just petitioned for a co-guardian here. Told them guardianship was granted in the state of California on this date. They've lived here for more than 6 months.
Did the parents have their parental rights
Yes.
and they just okayed that?
What I did is I sent service to the parent in California. They got served. I waited. They never responded. I went to court and said, here's our situation. Here's my order for a co-guardian. Granted, let's go. The hearing took
To
a,
get something like that.
Did find you an attorney. The,
Who's the attorney that you talked to?
you can,
He's an attorney.
Yeah,
Okay,
yeah.
I missed your introduction,
Yeah,
so I apologize.
no problem. I'm a local attorney. That's,
Okay, what's your name?
I'll give,
We'll give you a card.
yeah, I'll give you Carly, but, so, but yeah, I did that. I just served the parents and, there was no dad. Dad was deceased. I served mom in California.
Mom, they can't even find.
That might be the hardest part of that would actually be trying to do service because you have to probably going to add in the paper where mom used to live, where her last known location. That's where some expense may come in.
Well, not $10,000 worth.
No, it may not be that much, but I'm saying the hard part,
It's for adoption too,
Yeah.
But it was to terminate the rights.
you would, why don't, you need to talk about adoption. Adoption is not 10 grand. I'll go, that, that's
Several attorneys told me that. Well,
here?
talk once. Yeah, here and in Wisconsin both.
Okay. All right.
Also terminating the parental rights, is that's what would go through all the court and.
Yeah, I don't, okay. I don't think it costs you 10 grand. That's my opinion. I don't know which ones you talked to. I think they may have been a little excessive.
So the other reason that I've seen that people say, you know what, I don't want to be just a custodian anymore, or guardian anymore, is because we get tired of dealing with the bad actor parents, and we get tired of them being able to insert themselves constantly into the lives of the child or our lives.
Mhm.
And so I would say probably, have you seen that that's one of the main reasons?
That is
someone
one.
Would say, I just want to terminate their parental rights. They haven't worked the program. They haven't done what they're supposed to do and give this child a sense of stability.
Yes.
And knowing that they're not at risk of being ripped out of the home that they,
Yes.
come to be very comfortable.
I do that. I do it for that reason. I also do it for if I am, there's also different kinds of benefits you get as a child, not just someone you have custody of. So it may be that as a parent, like if I'm a dad and I get killed in an accident, my children may draw money, but if I got custody, they won't. So a lot of times you may terminate for and adopt for inheritance purposes, for different sorts of benefit purposes. Insurance a lot of times sometimes won't cover if you're a custodian. They won't let you use your insurance. So you may want to be a parent so you can use your insurance. There's a lot of different financial things as well. But termination, terminations are very complicated because there's two different things you have to do to terminate rights. There's two different actually standards of proof. One is, do you have grounds? And second, is it best interest? And unless you prove both of them, you don't get it done. So you can have all the grounds in the world, but if the court says it's not in the best interest, then you don't get to terminate. I defended one like that. I had a young lady who had a severe abuse finding in DCS. That's an automatic termination ground. So the grounds were there. However, she had been to rehab. She turned her life around. She was working, had a place to live. She was doing phenomenal. And court said, I'm not going to terminate this mom's parental rights. She's doing great. And so they lost the case. She ended up retaining her parental rights and got custody back. So you have to do both in order to actually terminate parental rights. And it can be a battle. There's no doubt about it, because parents do get legal counsel if they're indigent. They can get appointed counsel. If they lose, if the parent loses, this is where a lot of money would come in. So if I terminate your parental rights, if we go and have a trial and the parent loses, they get free appeals if they're indigent. That the attorney that they had appointed to them automatically files a notice of appeal. And if it gets appealed, then you're going to spend some money.
Is there an amount of time? that
30
they have to
days.
appeal?
30 days.
Yeah, because I mean, up in Wisconsin, they can appeal anytime.
It's
Doesn't
30
matter.
days. 30 days after the final order's put in court. So
Yeah, so I've been appealed, or at least brought through court, I don't know, 4 or 5 times.
but that's the guardianship. this is termination. A termination is different. Termination, if I have a guardianship, they can come back anytime and try to get the child back. A termination, from the time the order's entered, now I may terminate today, the order may take 2 weeks to get done, and then they have 30 days from the time the order's entered to appeal it.
Okay.
And if, like I said, if they're indigent, it's an automatic, it gets paid for, they have no skin in the game. And then it puts it out 6 more months while the Court of Appeals gets to it, and you'll spend 6 to 10 grand in attorney's fees on an appeal. Now that is very likely.
And that's maybe what they're talking about.
It's very much so, because a contested parent may appeal. I mean, that's very likely. That's something an attorney would discuss with you, should discuss with you. That's a negative that could happen. And that will cost you, because appeals are very time
And that's
sensitive.
only if the person is indigent, but if the person has some resources, then they would have to pay for it out of their own pocket.
Right.
So then it would be a lot less likely that they.
Yeah, these parents don't want to pay it back.
Right. Yeah. The cost of the appeal itself, excluding attorney's fees, is a few $100 filing fee. You file it with the court. There's a bond surety you sign, and it's filed. Now, to actually get the stuff done, it's going to cost you some money.
Especially if you have to pay for an attorney.
Yeah, because those are, it's very time consuming. Appeals are extremely time consuming. A lot of research. You basically write a book report, but it'll be very extensive, but you have all your case laws you got to find. You've got to go through transcripts. It's
Well,
very,
the lawyer has to hire private eye to verify.
no, all that's done. No, all they got to do is they'll have the transcript, and they'll say that it wasn't in the best interest of the child. And they'll go through court cases about what wasn't in the best interest, and they'll cite all these court cases. They'll attach their court report with it, and they have to refer to, cross-reference it, and back and forth with the judge's findings and what the testimony was. And so, as an attorney trying to go to page 3, line 103, and you're cross-referencing with this fact, and then it's very hard.
Why
Yeah.
is there nothing in place for a time limit? I have to say, my grandson's 16 and a half, I've known him since he was 6 months old. And there is no time limit. It has caused him, myself, you can tell, stress. And he is PTSD because his dad's always coming back.
Right. Yeah.
You know, it's horrible.
I'm dealing with not one that's been that long of time. I have one right now where it's been 7 years.
Why is
Mom,
there a time limit? 7 years.
I-
When is the
it's-
time limit?
There's just none as long as those rights are terminated, because the Constitution gives you inherent parental rights. They're forever. So they're not gonna put a time limit on your parental rights. That's why. But in the one I have now, mom is 30 miles down the road, hasn't contacted the children or hasn't seen them in 7 years.
My child has not
And-
seen his dad's farm out since he was 5 years old.
So mom comes back and says, I want my kids back. We now turn around and file a termination in opposition to that. And
Well,
so,
What happens is they get a boyfriend or a girlfriend. So they want the kid to prove that they're a good parent.
that does happen.
Happens all the time.
It does. But it can be, there's just no time limit. I mean, so I had to go to your specific situation, but a 16 and a half year old, if he can do it, if something were to happen, I don't know what kind of means he has after you pass.
He could apply for, what's it called? Where you-
Emancipation.
Emancipation, and he's talked about that.
And what
He
is
knows
that?
all about it.
Emancipation is 18.
No,
17,
that-
I think.
no, you can be younger. The emancipations are hard.
Yeah, I've heard they're really hard.
Because you've got to be able to prove to the court, you basically can take care of yourself and go to school. And so you have to be able to, so you have a job, I can pay my bills, if something happens, I'm on my own, because then there is nobody responsible for you. You're going to be signing to utilities, you're going to be renting, and so you got to be able to prove to the court, I can afford all of this, complete school, and do all of this, and you can trust me to do it.
Would he be applying for emancipation from his father, but not from his
No, it
grandmother?
makes him an adult.
It makes him an adult. It basically says, I'm this age, I am now legally, I can do anything an adult can do, even though I'm not over 18.
That it's used a lot for kids going in the military before they're 18.
I've only
Maybe he's thought
had,
about that just to be able to get emancipated.
I've had one young lady that was emancipated here. She had just turned 17. She was not quite when I petitioned. Her mom had brain cancer. Her dad lived in another state. She had basically been taking care of her mom. She was working. She was maintaining straight A's. She was doing all of this. And dad was like, I'm okay with it. And he didn't fight it. And she came to court, and the judge was overly impressed. Actually had school counselor, actually was a vice principal, came with her and was like, I think this and so we had a lot of support, and she got emancipated. But it wasn't easy. The judge was very skeptical of it. I mean, even though she'd been taking care of her mom with brain cancer, and her mom actually got put in a nursing home. And that's what we were afraid of. She actually had no guardian. And so she's still maintaining the apartment by herself, paying utilities and all that, while maintaining straight A's. And so the judge emancipated her so the DCS would not take her.
My grandson actually said, when he turns 18, he wants to get so adopted by me.
And that is as easy as pie.
Yeah, exactly.
That
It's
is,
like, why? Why does he have to wait?
you,
Does he have to go through all this?
now he has to consent to it at this point anyway. Over age 14, they have to consent.
No,
The child has to consent,
consent to what?
being adopted.
Oh, well, yeah. that's
So,
all he's ever wanted.
But that would play some into the court decision too. There's a lot in there. The costly part would be an appeal. Yes.
So we only have about 2 more minutes.
Sure.
Nathan, but I did want to say that I just recently found out, and if you're working, do you do adoptions
Yes.
as well? Okay, all right. The adoption attorney that handled our adoption here locally never told us this. Now, I think this is important. If you're a grandparent and you are solely responsible financially for caring for and having the custody of this child, it's not through DCS, it's not through a foster parent situation
Yeah.
where you're getting money, and you're retired, you actually can apply for Social Security payments for that child and get half of what you are receiving in addition to what you're receiving for that child. Once you adopt. So that's another reason why you might want to consider moving forward with adoption as well. No, but when we adopted, nobody told us that. It's been 2 years and I just found this out, so.
Well, that's why I said sometimes there's benefits you can get if you adopt that you
So
don't
as the
have as
adoption
a.
attorney, I would just say, please tell the grandparents that this is this is something.
Well, the reason, honestly, we just say you can check into all these benefits is because we're dealing with Social Security, dealing with federal government, and you never know what they're going to do. So to say you can do this, you may walk in, they say, we're not getting this. They come back to you mad because you said you could get it, and they may not get it.
Right, you
So
recommend they
you
check
can say,
into it.
look, you need to check into all the benefits you can get, and check in to see if there's anything available to you to do that. So.
Well, thank you so much.
Oh,
for
you're
being
welcome.
here
Thank you for
today.
letting me.
I mean, this was fantastic information, and we will be putting it out there online as well. Any disclaimers you need to make in order to be covered?
Yeah, well, none of this was technically legal advice.
Okay.
Each case is different. So you want to sit down with your specific case. There's all kinds of questions and facts. This is a very broad overview.
Yes.
You can spend a whole day just on one section of that
Well,
and
you
not
did an
cover it.
amazing job, so
Well, thank you.
so
I
much.
appreciate it. Thank you.
All right, so if anybody wishes, I'm sure that Nathan would be happy to give you
Yeah.
his card.